Intellectual property refers to creations of the mind, such as inventions, literary and artistic works and symbols, names, and images used in commerce. It is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. Imagine a world where anyone could steal an invention, a song, or a brand without consequences. Innovation and creativity would have no value. This is why intellectual property exists, protecting the ideas and creations that shape our world, from groundbreaking inventions to iconic logos and artistic masterpieces.
Republic Act 8293, also known as the Intellectual Property Code of the Philippines, is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for other purposes. It is a comprehensive law that consolidates and updates the various laws related to intellectual property in the country. It aims to protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations. This prevents others from making, using, or selling the invention without permission.
Declaration of State Policy. This section outlines the state policy on intellectual property in the Philippines. It emphasizes that a strong intellectual and industrial property system is essential for economic and creative growth. The government commits to protecting the exclusive rights of scientists, inventors, and artists, ensuring their work benefits the public. However, it also highlights that intellectual property serves a social function, meaning it should contribute to national development and the common good by promoting the sharing of knowledge and technology. Additionally, the state aims to simplify administrative procedures for patent, trademark, and copyright registration, liberalize the transfer of technology to encourage innovation, and to strengthen the enforcement of IP rights to ensure legal protection for creators and investors. In other words, the Philippine state policy on intellectual property balances the rights of creators with the broader goal of national development. It ensures that innovation thrives while benefiting society as a whole.
Based on the international conventions and reciprocity, this concept of reciprocity involves permitting the application of the legal effects of specific relationships in law when these same effects are accepted equally by foreign countries. In international law, reciprocity means the right to equally and mutual respect between states. The Philippines guarantees that foreign individuals and businesses from countries that have treaties with the Philippines or offer similar rights to Filipinos will receive the same intellectual protection as Filipino citizens. So all intellectual property rights, including patents, trademarks, copyrights, and industrial designs of foreign countries are protected.
The Section 5 comprises the functions of the Intellectual Property Office or IPO, which is responsible for enforcing intellectual property laws, processing applications, resolving disputes, and promoting technology transfer. Its functions ensure the protection of innovations and fair use of intellectual property. Let's go over each function one by one. First is patent examination and registration. The IPO reviews and grants patents for inventions while also registering utility models and industrial designs to protect new innovations and technological advancements. Second is trademark and geographic indication registration. It examines applications for trademarks, geographic indications, and integrated circuits to ensure businesses and creators receive proper recognition and exclusive rights over their brands and products. Third is technology transfer and dispute resolution. The office facilitates the legal transfer of technology, registers agreements, and resolves disputes to promote fair and efficient technology sharing. Fourth is patent information utilization. The IPO encourages the use of patent databases as a valuable tool for research and development, allowing inventors and businesses to build upon existing innovations. Fifth is publication of intellectual property rights. It regularly publishes a record of granted patents, registered trademarks, utility models, and technology transfer agreements to maintain transparency and public awareness. Sixth is administrative adjudication. The IPO has the authority to resolve disputes involving intellectual property rights through administrative proceedings, ensuring fair enforcement of IP laws. Lastly, policy coordination, and strengthening IP protection. The office works closely with government agencies and private entities to develop policies that enhance the protection and enforcement of intellectual property rights in the country.
So, the agency of the government in charge of the implementation of the Intellectual Property Code is the Intellectual Property Office, which replaced the Bureau of Patents, Trademarks, and Technology Transfer, and it is divided into 6 bureaus, namely Bureau of Patents, Bureau of Trademarks, Bureau of Legal Affairs, the Documentation, Information, and Technology Transfer Bureau, the Management Information System and EDP Bureau, and then the Administrative, Financial, and Personal Services Bureau.
Office of Director General is responsible for overall operations. Under this office, the 3 division. Enforcement Division handles and enforcement in intellectual property law. Legal and Appeal Divisions manages the legal concern and appeal related to intellectual property rights. Policy Research and Information Affairs Division, conducting research and formulate the policy related to intellectual property. Office of Debut Director, Generally and Operations and Legal Affairs. This is the Office of Management of core functions of intellectual property of Office of the Philippines related to registration and protections of intellectual property. So first is the Bureau of Parents, the process parents, application and exam inventions, unity, model, and industrial design. Bureau of Trademark, handles and trademark application ensuring the brand protection. Bureau of Copyright and other related right is oversees copyright registration related to right including the creativity sector development. Bureau of Legal Affairs that deals with legal disposure, authorities, and case management. Office of Deputy Director Generally for Policy and Management Service. This office focuses on policy making management, administrative service. It oversees 3 divisions. Documentation, Information, and Technology Transfer for Bureau, Management, Publication, Library Service, Information System, and Digitalization Effort. Financial Management and Administrative Service, handles of financial and administrative function. Manage of Information Service, focus on the application databases, management and IT system of intellectual property of the Philippines.
First is the Bureau of Patents. So the Bureau of Patents is a government agency in the Philippines responsible for examining and granting patents for inventions. So the Bureau of Patents mandates the use of patent information as a tool for technological development. So they examine applications and grant patents or register utility models including industrial designs, trademarks, geographical indication, and integrated circuits. So if an application meets the requirements, they grant a patent which gives the inventor exclusive intellectual property rights to their invention for a period of time. And they also help protect copyright by assisting the facilitation of deposits of work with the National Library.
Number 2 is the Bureau of Trademarks, which is responsible for handling trademarks, geographic indications, and other marks of ownership. And according to this Republic Act, the Bureau of Trademarks shall have the following functions. Number 1 is the search and examination of the applications for the registration of marks, geographic indications, and other marks of ownership and the issuance of the certificates of registration. This is to ensure that trademarks comply with legal requirements before issuing certificates of registration. Number 2 is to conduct studies and researches in the field of trademarks in order to assist the Director General in formulating policies on the administration and examination of trademarks. This function ensures that the trademark system remains efficient, fair, and aligned with global best practices. Essentially, the Bureau plays a crucial role in ensuring that trademarks are properly registered and legally protected, while also contributing to policy development in this field.
Next is the Bureau of Legal Affairs. It handles legal disputes related to intellectual property rights. It also resolves conflicts on trademarks, patents, and other intellectual property registrations. The Bureau also investigates complaints issues cease and desist orders, and imposes fines to protect the rights of creators and the inventors. So next is the Documentation, Information, and Technology Transfer Bureau. It promotes intellectual property awareness and technology transfer. It supports patent searches, maintains information system, conducts seminars, and helps register technology transfer agreement. The Bureau also builds partnerships with the research institutions and assists in resolving technology-related disputes.
So next is the Management Information Services and EDP Bureau, which plays a crucial role in maintaining and improving technological infrastructure. And it is responsible for various functions including automation planning, research and development, system testing, contracting with firms, purchasing and maintaining equipment, designing and maintaining systems, and providing user consultation. So it is responsible for a broad range of tasks, starting with the critical function of automation planning. And this involves strategizing and implementing technology solutions to streamline processes within the IPO, ultimately leading to increased efficiency and productivity. And beyond planning, the Bureau also handles the development, maintenance, and enhancement of the IPO's information systems, ensuring that the data is accurate, accessible, and secure. Furthermore, they manage the IPO's IT equipment, providing support and troubleshooting to keep the office running smoothly. So next is the Administrative, Financial, and Personal Services Bureau, in which the administrative services manage procurement, payments, office maintenance, and regulatory compliance, including fee collection for application and publication of intellectual property, related applications and grants. And then the Patent and Trademark Administration Services, which maintains registers of intellectual property, related documents, collects maintenance fees, issues certified copies, and safeguards application, patents, and registration certificates. And also the Financial Service, which focus on financial planning, fund management, and monitoring financial operations. And finally, the Human Resource Development Service, which develops and implements plans for employee development, addresses manpower needs, and aims to maintain a positive employee morale.
Under the intellectual property law, there's also the law on patents, and let us briefly talk about it. Starting with Chapter 1, the general provisions of patent law. So what is a patent? A patent is an exclusive right granted for an invention, allowing the patent holder to exclude others from making, using, or selling the invention without permission. This legal protection promotes innovation and ensures inventors can benefit from their work. Moving on to Chapter 2, Patentability. Not every invention can be patented. To qualify, an invention must meet 3 key criteria. First, it has to be new, meaning it hasn't been publicly disclosed before. Second, it must involve an inventive step, meaning it's not something obvious that someone skilled in the field could easily figure out. And lastly, the invention must be industrially applicable, meaning it should have some practical use in an industry. However, there are certain things that cannot be patented. For example, abstract ideas such as mathematical theories or concepts without practical applications are not eligible. Natural discoveries like existing plants or minerals are also excluded as they are not created by humans. Additionally, methods of medical treatment are often not patentable, particularly in some jurisdictions, due to ethical concerns about monopolizing essential healthcare practices. Next is Chapter 3, Right to a Patent. So, who gets the right to a patent? Generally, the first person to file a patent application is granted the rights. If multiple inventors are involved, they share the rights unless there's an agreement stating otherwise. Employers may also claim patent rights if the invention was made during employment. And Chapter 4, Patent Application. So let's talk about the patent application process. The application must include a request form, a detailed description of the invention, claims defining its scope, drawings if necessary, and an abstract. The application is then examined to determine if the invention meets all legal requirements.
Next is we're going to talk about Chapter 5, the procedure granted of patent of the intellectual property law. First is the filing date requirements, which is found in sections 40 to 41. It is stated here that the patent application is officially considered filed once the patent office received the following: a request to file a patent, details about the applicant, a description of the invention must include at least one claim. So if any of these required elements are missing, the applicant is given a time limit to fix them. If the applicant failed to correct the missing elements within the given time, the application is withdrawn. Next is the formality examination, which is found in section 42. Once the filing date is granted and the applicant pays the required fees, the patent office checks if the application meets the required formal requirements. If there are issues, the applicant can request an appeal or examination according to the regulation. Next, we're going to talk the classification, search, and publication, which is found in section 43 to 45. It's stated here that the patent office classified the application and searches for prior art to check if it's still new. After 18 months, the application is published in the IPO Gazette official patent publication. However, if the invention is important for national security, publication may be restricted. So before publication, the application remains confidential and not accessible to the public. Next is the right after publication and third-party observation, which is found in section 46 to 47. Once published, the applicant gets provisional rights, meaning they can protect the invention even before the patent is officially granted. Third parties or other people or companies can submit observation or argument if they believe the invention should not be patented. Next is the substantive examination and amendments, which is found in section 48 to 49. The applicant must request a substantive examination within 6 months of publication for the patent office to fully evaluate the invention. The applicant can amend or modify the application, but they cannot add new subject matter that wasn't in the original field. Next is the grant or refusal of patent, section 50 to 51. If the application meets all requirements, the patent is granted and published. And if the application fails to pay the required fees, the application is withdrawn. If the patent is refused, the applicant can appeal the decision. Next is the patent term, fees, and surrender, which is found in section 52 to 56. A patent lasts 20 years from the filing date, and an annual fees must be paid starting from the 4th year to keep the patent valid. Failure to pay result in the patent expiring. And a patent can be surrendered if all relevant parties agrees. Lastly, the correction and changes. The patent office can correct mistake in granted patents, and the patent owners can make limited modifications such as correcting errors or restriction claims, but cannot expand the patent beyond what was originally filed. All amendments must be officially published to inform the public.
Next is Chapter 6, which covers the cancellation of patents and substitution of patentee. For patent cancellation process, any person can request to cancel a patent or just parts of it if the invention is not new or patentable, unclear or incomplete, or if it violates public order or morality. The petition for cancellation must be written and verified with other supporting documents, and the translation into English is required if the documents are in other languages. Notice of the hearing is served to patentees and stakeholders and must be published in the IPO Gazette. In the technical review process of petitions, it is headed by a committee of 3, led by Director of Legal Affairs, which handles complex technical issues. The committee can order cancellation or maintain amended patent, and cancelled patent rights are immediately terminated, and cancellation decisions are immediately executory unless restrained by Director General. Next is Chapter 7, which outlines the legal remedies for a person who has the rightful claim to a patent but was not initially recognized as the patent holder. The person declared by the court as having the right to patent has 4 options within 3 months after the decision has become final. First, they may prosecute existing application, file new application, request refusal, or seek cancellation if patent has already been issued. The court can order substitution as patentee or cancel patent if inventor was deprived through fraud, and damages may be awarded if circumstances warrant. Then we have Chapter 8, where it states that patent owners have exclusive rights to control the making, using, selling, and importing of their patented products or processes. They also have the rights for their patents to be assigned, transferred, or licensed. Patent uses are allowed on certain unauthorized uses such as for non-commercial, educational, or scientific purposes. However, there are special provisions for drugs and medicines regarding market introduction and government use. Government can use patented inventions without the owner's consent in cases such as public interest, national emergency, or health concerns. And fair compensation must be provided to patent owners. Acts of infringements include unauthorized making, using, or selling of a patented invention, and patentee are provided with legal remedies including damages and injunctive relief.
In a patent infringement case, the defendant has the right to challenge the validity of the patent, arguing that it was improperly granted or does not meet legal requirements. If the court finds the patent to be invalid, it will officially cancel the patent, and this decision will be documented. To assist in complex cases, the court may appoint expert assessors with specialized knowledge, and the cost for these experts are initially covered by the complainant. For individuals or companies that repeatedly infringe on a patent, strict penalties apply. These can include imprisonment for a period ranging from 6 months to 3 years, along with fines between 100,000 pesos and 300,000 pesos. However, legal action against repeat infringers must be initiated within 3 years from the date of the infringement. Technology transfer encourages innovation and economic growth while preventing exploitation. Royalty disputes are managed by an appropriate bureau to ensure fairness. Agreements must not impose unfair restrictions on sourcing, pricing, production, competition, or research promoting a free market. Governed by Philippine laws, disputes are resolved locally. Licensors handle taxes and ensure improvements remain accessible. They may issue multiple licenses, and licenses have usage rights for contracts' duration. Special exemptions for economic benefits may be granted, but agreements violating these rules are unenforceable without official approval. This framework aims to promote fair technology access while safeguarding businesses' interests and national development. Compulsory licensing allows third parties to use a patent without the owner's consent under specific conditions, ensuring essential technologies and medicines remain accessible. It applies in national emergencies, public interest cases, anti-competitive practices, or when a patent is not utilized. In pharmaceuticals, it facilitates the import or export of patent drugs, benefiting countries with limited manufacturing capacity. Some licenses require a waiting period, but urgent cases can proceed without prior negotiation. For semiconductor patents, licensing is available only for public, non-commercial use or to prevent unfair competition. The process includes verified applications, public hearings, and notifications to ensure fairness and due process, while also providing patent owners with fair compensation. This system balances innovation, protection with public welfare, preventing monopolies from limiting access to essential advancements.
Chapter 11, Assignment and Transmission of Rights, Section 103 to 107. The law protects patent as property, meaning they can be transferred like any other asset. These rights can be assigned through contracts, inheritance, or licensing agreements. Assignments must be in writing, acknowledged before a notary, and recorded with the Intellectual Property Office. Without proper registration, the assignment is not legally binding against third parties. If 2 or more people own a patent, they have equal rights but need each other's consent for certain transactions. Next is Chapter 12, Registration of Utility Models, Section 108 to 111. Utility models provide patent-like protection for minor innovations that are new and industrial useful. They follow patent laws but have a shorter lifespan of 7 years without renewal. If a patent application is not strong enough, it can be converted into a utility model and vice versa. Registration requires compliance with strict requirements, or it may be cancelled. This system helps protect simpler inventions that may not qualify for full patent protection. Chapter 13 Industrial Design, Section 112 to 120. Industrial designs protect the aesthetic aspects of a product, such as shape, color, and patterns. To be registered, a design must be new, original, and not purely functional. Applications must include visual representations, applicant details, and a clear descriptions of the design. Registration lasts 5 years and can be renewed twice for a maximum of 15 years. If a design is found to be copied or does not meet the originality requirements, it can be revoked.